Bonsoir tout le monde. Hello everyone. Je suis extrêmement heureux de vous accueillir aujourd'hui à l'Université d'Ottawa pour ce nouvel événement du Centre de recherche en droit, technologie et société. I am delighted to welcome you tonight at the University of Ottawa for this new event of the Center for Law, Technology and Society, co-hosted with the Canada Research Chair in Cybersecurity Law at the University of Calgary, in collaboration with the University of Ottawa Research Chair in Technology and Society and HC2P, the Human-Centric Cybersecurity Partnership. For those who don't know me, my name is Florian Martin Barito. I am the University Research Chair in Technology and Society and an Associate Professor of Law in the Common Law section at the University of Ottawa, and I'm the Director of the Center for Law, Technology and Society at UOttawa. First, and in the support of reconciliation, it's our custom to offer and introduce affirmation when we host guests on campus, and it seems even more important when we discuss new tools of power and control and online harms. So we want to pay respect to the Algonquin people who are the traditional guardians of this land. We acknowledge their long-standing relationship with this territory, which remains unceded. Nous rendons également hommage à tous les peuples autochtones, qu'ils habitent Ottawa, qu'ils soient de la région ou d'ailleurs au Canada. Tonight, I am delighted to host a conversation on the latest development in Canada's tentative to govern online harms. A month ago now, the Minister of Justice tabled Bill C-63, that has a very long name, but the Online Harms Act for short, that also Rights Act and so on. The proposal has been met with praise and criticism. The debate got quite heated very quickly, and a lot has been said on this bill. A month later, we're hoping to unpack some of the key aspects of the proposal with some of Canada's leading legal thought leaders on this topic. And so I'm delighted to be joined tonight by Jane Bailey, full professor of law at the University of Ottawa, Michael Geist, who is the Canada Research Chair in Internet and E-commerce Law and a full professor in the Faculty of Law at Ottawa too, as well as Sunil Gurmukh, who is an assistant professor and assistant dean Equity, Diversity, Inclusion and Decolonization at Western Law. And finally, but not least, we have with us tonight Emily Ledlaw, who is the Canada Research Chair in Cybersecurity Law and an associate professor in the Faculty of Law at the University of Calgary. Emily was also the co-chair of the government's expert advisory group on online safety, and I had the pleasure to sit with her on the Council of Canadian Academies expert panel on public safety in the digital age. And on this topic, I highly recommend you to read CCA's Vulnerable Connection report for evidence from around the world on this topic. Emily and I will be facilitating the conversation tonight with our speakers, but also with you, the audience, people online and people in the room. If you're online, please ask your question via the Q&A function. And if you're in person, we'll have mics like in both alleys for you. Et bien que notre événement soit en anglais ce soir, n'hésitez pas à poser vos questions en français si vous êtes plus à l'aise de les poser en français. Émilie et moi sommes tous les deux parfaitement bilingues. And without further ado, I will hand it over to you, Emily, and kindly ask you to remind us, where we're coming from and how we got to this bill.
Thank you. Merci, Florian. I think one thing to note as we do get into this discussion is that Canada has introduced this bill on the heels of major legal developments in other jurisdictions. The EU passed the Digital Services Act recently. The UK passed their Online Harms Act, and Australia has had an e-safety commissioner in place for, I think, 7 or 8 years at this point. The process, and I'm trying to recollect exactly when it began. I think it's about 3 years ago. The federal government began consulting with various groups about a potential, I guess, online harms bill. A proposal was brought forward in the summer of 2021, and it was quite widely criticized. And then after the election, they regrouped and engaged in various consultations. There was the expert group that I was a part of, but there was also a Commission on Democratic Expression, two parts of that, a Citizens Assembly, and then various consultations across Canada. And then what we have now is the proposed Online Harms Act. Now, it's really a few different types of online harms regulations in one bill. I know that there's been some discussion and criticism about whether they should actually unpackage this bill into a few different things. I think we'll discuss that. But one thing to think about as we go forward is from an individual perspective who's suffered harm, these are the different ways that they might seek recourse. So you have the Online Harms Act proper, which is about 90% of the bill, and it looks at the creation of a regulator or a commission in the form of a digital safety commission, an ombudsperson, and both supported by a digital safety office. It regulates certain social media services. That's the point I'd like to discuss with everybody. You know, it's looking at large social media services, excludes private messaging, but it does include live streaming and adult sharing sites. It covers 7 online harms. If I look at the list, it is, intimate images, content that sexually victimizes a child or re-victimizes a survivor, content that induces a child to harm themselves, content used to bully a child, that foments hatred, incites violence, and incites violent extremism or terrorism. And very briefly, it looks at creating a graduated scheme where the strongest obligations are related to intimate images and content that sexually victimizes children, where that would be where content removal has to happen quite rapidly through the Digital Safety Commission. Then a special duty to children, looking at really embedding safety by design principles for all the different ways that, even when you look at those harmful types of content that is captured by children, whether it's child sexual abuse images or you're looking at child bullying and so on. And then the third category would be the duty to act responsibly. This was a recommendation of the Commission on Democratic Expression. I know the panel that I was a part of really, we circled around that idea very quickly. We thought it was a good one. And this is about companies kind of at a systemic level embedding digital safety plans to address all these types of harmful content. It's not about content removal exactly. It's about how they design and justify their approaches to address safety issues in those spaces. Now, the other acts would be amendments to the criminal code. I'll leave those to talk about. These have been receiving quite a bit of criticism and looking at risks of life in prison, a new hate crime offense, the idea of peace bonds. There is a proposal for reintroduction of Section 13 to the Canadian Human Rights Act that would enable complaints to be made to the Human Rights Commission. And then the last category, which we're not going to cover, mainly because everyone generally supports it, though some very important amendment, would be changes to the Mandatory Reporting Act that essentially ensures that even social media services need to be reporting child pornographic content to the appropriate authorities and creating a centralized law enforcement body essentially to receive that information. I'm going to leave it there. That was even longer than I planned to talk, but I guess this sets us up for the conversation that we would love to have with everybody today. Do you want to kickstart it? We're going to start with the Online Harms Act. We're going to work through the order of the act itself. And part of the reason is I feared if we start with the Criminal Code and the Human Rights Act, that is all we will talk about. And there's some really important points to dig into for the Online Harms Act itself. So one point I wanted to start with would be a question about who exactly is regulated. So the bill targets social media services. who's captured by this? Is it, scoped properly? Are there risks to it? Maybe, Michael, I'll turn to you, and you could kickstart us with this conversation.
Okay, sure. Let me start just by thanking Emily and Florian for putting this together, and there's a lot of familiar faces in the room, so it's great to see you all here. If it's okay with you, I just wanted to take a step back, if you don't mind, just quickly to note that I'm glad we're starting with this aspect of the bill, because while I think there are concerns, and hopefully we'll have a chance to get to them, the reality is I think that there was a lot of concerns from many, having seen what took place in 2021, that the government wouldn't necessarily listen to what the kind of feedback that they'd gotten, and we'd get basically a rerun of what we saw in the consultation. And I think it's fair to say that that's not what's happened on these provisions in particular. And so I think, unlike, to an extent, some of the other internet-related provisions that we've seen come out of the government, C-11 and C-18, this one really does feel more policy-driven, and I think in a positive way. So I think that's really a positive. In terms of not only this issue, but whether the right harms are covered and the like. I mean, these kind of line drawing exercises, I think, are exceptionally challenging. And, I think the fact that they are looking for large players with thresholds that will identify only some of the largest players, which I think leaves some to say, this is simply going to drive some of this content underground, or to some of these sites or services that that are less visible or have less connection to Canada. On the one hand, tells us, and I think it's fair to say, that this is not a silver bullet that solves everything, nor should anybody be under any illusion that it would be. It strikes me that part of the language in there talks about mitigating some of the harms, and it seems to me that that's what's trying to be achieved. And so I think, quite frankly, if we can find a way to target the very largest players, which is precisely what this legislation seeks to do, that for many has a positive effect in terms of, I think, changing the dynamic in terms of some of the harms that take place on those largest places. There's a reason they have the largest amount of impact. That won't, though, have the effect of removing all of the various harms from the internet or from the ability to access that. But that's simply the reality, I think, of sort of choosing something that will be as effective as possible without setting a bar at a level that, frankly, would leave people to feel that this legislation just is never going to really accomplish much of anything, because, of course, we're not going to be able to regulate every internet service around the world.
Well, and one thing I'll just add in before you continue is there is a really unique provision in the bill here. The microphone's facing me. So it's targeting large social media platforms, but it also can designate certain platforms if they are posing a significant risk of harm. And from what I've looked at, that is unique globally as a provision that enables then designation of certain bodies if it does become a social media service that's just dominated by hateful messages, or the sharing of child sexual abuse images and so on.
That's true, and others may want to jump in. This jumps ahead a little bit, but I think the fact that there is that flexibility, and I think, frankly, there's a lot of flexibility everywhere, is one of the reasons why we have seen a fair amount of support for this. In part because I think people look at this and say, well, it sounds pretty reasonable to have a duty to act responsibly, or to identify other sites that might not otherwise be immediately covered. But in some ways, we're punting on many of the really hard questions here, right? So, a digital safety plan seems perfectly reasonable, and I know we'll come to that. But we don't exactly know what a Digital Safety Commission is going to say has to be in that digital safety plan. They've got powers to create a wide range of different regulations. What happens when the plan, or if the plan, suddenly does incorporate all kinds of things that people don't necessarily envision right now, but they say, well, this is what we think is going to be necessary to address some of these harms. I think people may find this to be a far less reasonable bill than they are saying right now. And so I think, in some ways, I'm okay with this as the framing, but I think we ought to recognize that, I think, at least in my mind, some of the supportive comments we're seeing is that there's still a lot of detail yet to come, and we're entrusting basically the Digital Safety Commission to come up with it. And when we come to that, to me, that's where some of the concerns lie, actually.
So I'm curious what you both think there, because I have very strong views on that particular point, but I am also conscious I'm a moderator here, and we have some experts that I will ask to maybe weigh in on this, and
Sure.
I'll tease out a few things. Yeah.
Yeah. I think there's something to be said for when nobody seems exactly happy with something, that maybe that's a sign that you're kind of getting it right. Because this is something that's hard to get absolutely right. And my catchphrase with respect to this legislation has been, you got to start somewhere. And this, it's a, as Michael has said, it's a far cry removed from what was initially discussed in the consultation process, which was a really concerning uniform approach to very different kinds of content. So I think Michael's right. The other provision, I think that I don't know if many people are talking about it, that I think is super important, is the 5-year review, because I think that we're in a learning process. We're trying something. We're entrusting a commission who I hope will be very well staffed and resourced, and very well informed about principles of equality in particular. And we're going to learn, hopefully, if things go to plan, we're going to learn a lot about the way platforms are doing things that we've all wondered about for a very long time and not really been able to find out. So I think this is as much as anything is an information gathering process, and that 5-year review compels us to go back and say, what have we learned? And then maybe things have to change. Maybe we have to clamp down. Maybe we have to ease up. Maybe, I think that it's there has to be a fluidity in it, and in some ways we go into that with a certain leap of faith.
So I want to thank the University of Ottawa and Calgary for having me. My brother graduated from University of Ottawa, the law school here, and we went to different paths. So I always joke. So my brother, he's a partner at a large firm in the tax group, and I'm a human rights lawyer. So we always joke, my brother, he steals from the poor and gives to the rich, and I steal from the rich and give to the poor. So together we provide no benefit to society. So we're really grateful for our legal education. And in typical lawyer fashion, here's a disclaimer. So I'm on leave from my role of counsel at the Ontario Human Rights Commission. So these are my views alone. They don't represent the views of the Ontario Human Rights Commission or the Ontario Public Service. So Michael talked about a slippery slope, right? What happens if the digital safety plan includes something that wasn't envisioned and it's not reasonable? And, what if, and we can think further down the line, what if there's a finding that a social media service wasn't complying with the act, right? Well, it's subject to judicial review, right? These decisions. So it's not just the Digital Safety Commission that holds all the cards here. The Digital Safety Commission has to act in a way that's reasonable, right? And of course, we want to make sure that the Digital Safety Commission is sufficiently staffed and has resources and expertise, right? If I asked all of you, could you predict that Snapchat would emerge 15 years ago? You would never be able to do that, right? So there must be some inherent flexibility in the ability of a regulator to respond to trends, of course, right? And it makes sense, what if there's a new platform that emerges? So you want to leave the door open for regulated services. So to me, that all seems to make a lot of sense. And if we think about the changes from the old version of the bill and the new version, you have a takedown requirement for revenge porn and child sex exploitation. The takedown to 24-hour takedown requirement, it used to apply to all the different types of harmful content, or at least hate, and now it doesn't, right? So, and we know that private messaging isn't covered either. So this, in my view, better reflects freedom of expression too.
Well, the one point I'll add, and sorry, Florian, you just tapped me, is I I think that point about it being a bit of a leap of faith is important, and to the extent that we need a flexible regulator. And I know Florian and I separately have had the conversations about what is it that you need to put in the legislation and what is it that you have to leave later for to be developed through regulations, and what needs to be developed through guidelines, do you need freedom for a digital safety commission to be able to develop on their own. And one of the big struggles in this area is that you're dealing with such fluidity about the types of companies, the types, how the harm is happening, how you enable and protect individuals, that it requires us to take that leap of faith, to have this commission have that flexibility to be able to develop the types of rules and practices that are going to be necessary. So I like to look at the legislation and say, what concretely do we need as guardrails that are hard and fast in the legislation themselves? So some of the things that I saw that were really important were anything that commission develops in guidelines and regulations has to take into account freedom of expression, privacy, equality. Those are the things that are hard, but what's left till later might be, okay, how do we think through maybe what mitigating risks of harm actually looks like at this moment to develop in terms of regulations. I think you could say, though, that the commission, maybe they should set down the expertise that they think a digital safety commission should have, that maybe that should be set down in the legislation. That would be an amendment I would recommend.
And maybe I know that, Michael, you want to react, but maybe also on the question of the scope, there has been like a conversation about the fact that, like private messaging, like the features of all those kind of platforms are not covered by the act. Is it a good idea, not a good idea? And I think it might. I think it's a good idea. So when you think of like the privacy of the users and like freedom of expression and making sure you don't have like some filters in those tools. So, but we could debate about this. But something I would like to kind of put my finger on in all of you. At first we said like social media because this is the announced purpose and goal, like the scope of the act. But you all went to platform, and this is something that like the act, like define social media service, but they're not defining social media services. They're just defining almost any website, any platform, because it covers like any website or app that enable the access and sharing of content. So it's basically what we call Web 2.0. It's everything. It's also like Wikipedia, and all the Wikimedia ecosystem. Like, is it something that was in the spirit of the act and the legislator is something that is to be covered or not? Is it a good thing, a bad thing? I'm not sure. But then when we look at some section of the act, with some like fees and stuff for like cost recovery, you're like, do we want to have like a non-profit organization such as Wikimedia treated the same way than like Meta and Google and like, I don't know. That's the kind of question that when you go look at some definitions, like, yeah, there is the word, but then there is the meaning of the word that is a bit different in the bill. And yeah, I've been struggling with this, but Michael, I know that you want to.
I ended up with this very long list of things I wanted to say. So I'll just pick up. So Jane's a dear friend, but 5-year reviews are completely useless. We have 5-year reviews in the Copyright Act. We have 5-year reviews in PIPEDA. The PIPEDA, I remember in 2012 with the second private PIPEDA review, there was no review. And the minister at the time, James Moore, appeared at the committee and was asked by one of the MPs, what happened to the review? And his response is, I'm here. You have any questions? These reviews just don't have any sort of effect. Government runs at their own sort of pace. It is incumbent to get it right, and I don't believe that we can take much solace at all in the notion that, well, we'll look at this again in 5 years' time and we'll try to fix it. Whatever the government is, they will wait to the absolute limit, then they will schedule it for a hearing, they'll do a hearing, it'll take another year before they get to the point of some sort of recommendations, and government will say thanks for the recommendations, and we've seen in other instances it could take years and years and years to take place. The notion that we're going to get a well-staffed commission, seriously, yesterday on Sunday, the government introduced its AI funding strategy, which includes $5 million for enforcement of the C-27 elements of AI, basically creating a new data commissioner. $5 million. If we think that we're gonna get tons of money plowed into this, that strikes me as very unlikely. The more likely thing is they're just gonna ask the platforms to fund all of this, which is one of the mechanisms. But I can't say that, based on at least recent experience, I'm particularly optimistic around a lot of this. And I do think it's striking that where panelists have been citing stuff they like about the legislation, it's when there are specifics. It's like, you did a good job of trying to do this or define that. And that's where, so I think that more guidance in that respect. I get the value of saying things change and we need flexibility. And of course we do. That's one of the reasons why I think the trust will ebb and flow based on this Digital Safety Commission, and saying a commission isn't required to follow traditional rules of evidence, or creating a maximum 5-person commission given the just range of issues they have to deal with, or given this laundry list of new regs that they can establish on just about every issue under the sun, doesn't really provide, personally with me, with a lot of confidence, when the whole goal ought to be ensuring that you've got an enforcement system that people do have some confidence in, and giving as much guidance in advance as possible, so that we've got some of those specifics, so we know where the guardrails are in the legislation. I feel somewhat less comfortable with the notion that the guardrails come from judicial review of this yet to be created commission, or the fact that we can fix the mistakes we made as part of a 5-year review that is far more likely to take 10.
I mean, the one thing that I do want to pick on just for a second is, I think that, the rules of evidence aspect of it is admin law, like at its core. This is consistent with admin law. The whole point of regulatory agencies is that they provide access to justice in a way that the courts don't provide. And the rules of evidence, strictly speaking, when you're talking about hearsay, expert evidence, like similar fact evidence, you name it, are way too difficult for regulatory agencies to be able to meet up to, but they still have to meet the rules of procedural fairness. So that same provision about the idea of evidence, you see something similar in privacy legislation and PIPEDA and the CRTC, if you're looking at the Immigration and Refugee Board, right? And so I can see that if you're like, there's certain things that we want to strengthen, that absolutely would be an interesting point to explore. But that starting point of this is actually just how admin law works is really important, because if a commissioner has the power to say this is child sexual abuse image and that's what it looks like and I want to order it taken down, if you brought in the rules of evidence at that point, then it wouldn't happen, right? So you need to have that, that flexibility there. So. Sorry, Sunil, I know both of you maybe have. I'll stop talking so much.
No.
I wanted to comment on the 5-year review, because I understand the point. At the same time, without that, then there is actually probably almost no chance that anybody's ever going to talk about it, right? The reviews with respect to PIPEDA have not been particularly fulfilling. But at the same time, it forces some sort of dialogue that we otherwise aren't having, right? So and certainly just to be clear, there's lots here that I'm not happy about, the lack of clarity in. So I'm not saying there isn't room for clarity, for clarifying, and that the one that I would talk about is the duty to protect children. A lot of my work has focused on work with young people, and I absolutely understand the need for service providers to play their role in if they're have services that are exposing children to harm, and they are. But there is a certain irony in that, which is that at the same time, the way that platforms are set up and the way that they amplify harmful content plays a very serious role in harming children. and setting them up for conflict with one another. And so there's a way in which, you're sort of saying, we're kind of got the cat minding the canary. And that worries me. And the regulations that the commissioner might, the commissioner may come up with some of the suggestions about what it is they should be doing. Age-appropriate design, it's very interesting, but it doesn't get at the fundamental problems of the model, right? It accepts the model and says, let's just tinker around the edges. And parental controls. I totally understand that, but we also have to think. I really hope that we're thinking beyond ways of putting kids under surveillance, which has been our go-to all along, and thinking more about ways. One of the things we're doing here is beginning the process of putting the platforms, the service providers under some form of a microscope, to creating some form of transparency and accountability. And that's really important. And I hope that things don't happen that pull us away from that and relocate responsibility and relocate suspicion back on young people.
I agree that transparency is very important. And then just talking about the rules of evidence, right? The Digital Safety Commission doesn't have to abide by technical rules of evidence. That sounds really scary, right? But what if revenge porn or child sex exploitation, what if it was posted by a user who used a pseudonym, right? So you don't have direct evidence. You don't have testimony from a witness who actually saw, that was the user, I saw them post it. Or a document that directly establishes that, it was that user, right? But if it's, for example, if we're thinking about revenge porn, you might have some circumstantial evidence, right? Hearsay evidence that, the boyfriend uses this pseudonym, or that, it must have been the boyfriend given when the time that this happened, right? And in fact, the Canadian Human Rights Tribunal has accepted hearsay evidence to identify a perpetrator in the case of Warman and Kuba, right? And this is an old case from 2006. This is when Section 13 was still on the books. Mr. Kuba was using pseudonyms, Proud 18 and White Euro Canadian. And Kuba used what he called true stories and news reports to justify unfounded and racist generalizations. His messages vilified Indigenous Canadians, Black people, Jewish people. He characterized those groups as sexual predators. But the way that he was connected to that pseudonym, it wasn't through direct evidence, right? So this is, when you think about that and how these things actually work in practice, when we think about these examples, that's it makes sense, right? That you got to move quickly and you got to be flexible. And, let's think about it some more, right? So if there's content on a site like Pornhub and a user files a complaint with the Digital Safety Commission, and the commission says it's not frivolous or trivial, the commission would make an order that it be taken down without delay, right? Do you want to wait for a full hearing where the victim would appear, the evidence is formally entered, and be cross-examined by the platform or the person who posted it before you be required to take it down?
So are we talking about revenge porn that's already required to be taken down in 24 hours, or are you talking about some other?
Well, there's also the complaints mechanism in the online safety bill, right? So, yeah, if it's flagged, you got to take it down in 24 hours, but then a victim can file a complaint about it if they see it up there too, right? And then the Digital Safety Commission has to move super quickly. But are we going to wait for a full hearing?
Well, the law talks about moving both expeditious, speaks to the evidence issue, speaking about the need to act, I think the language is informally and expeditiously. And while I get the need to move quickly, some of the other kind of rationale that we've just heard is not actually cited in the legislation as the rationale behind it. And that when I see the juxtaposition between the powers that this commission has been given on the one hand, and saying that, well, we wanted to act informally on the other, I have a really hard time reconciling that.
Maybe I would like, so we started like the deep down in some of the very specifics of the act, but maybe I would like to just go back to like the general approach. And so and you kind of already like unpacked a lot of the content of the bill. We have like the duty to act responsibly. We have the special duty to kids. We have take down for specific content. And also there is those rule about like the need to address like algorithmic amplification and making sure that the system don't amplify content, harmful content. And Jane, you said that it's more like design, not so much attacking like the model of those platforms. Maybe I would disagree a bit because we know that a lot of the business model is actually like to amplify harmful
Right.
content. So it's kind of so like kind of tackling the business model issue, maybe like indirectly. So I think that's interesting. So we have a lot, but is it kind of enough, or do you think that there is a lot like important things that are not like covered, like type of harms that should have been included? Um, yeah, maybe Jane, Jane, if you want to.
I when I look at the list of harms, I think it's fairly comprehensive. Again, maybe I'm a little Pollyanna about this, obviously, but I think that again, you have to start somewhere. You've got to be cautious about not putting too many things, likes that aren't likes and unlikes together, which was what was happening in the online consultation. You should not treat terrorism like you treat non-consensual intimate images, and the kinds of responses that people need and deserve are different. And so I think it's careful in that sense. Might there be things I'm not thinking of? Maybe, and maybe people will sort of bring those forward and suggest that they be added. I think maybe one thing we haven't really talked about is the point in all of this, that in terms of my research over the years, that's the most important feature, is the ombudsperson. Because when we've talked to young people time and again, they tell us, like law, yeah, like we get it. For extreme cases, of course, we need law, but there's all kinds of reasons not to go to law in a lot of these circumstances, including the publicity that's created as a result of legal proceedings. And what we want somebody to go. We know, who do we go? Who can we go to? We report things to the platform, and we don't always know what happens. This act would start to help make that better. But to have a place that people can go for support and advocacy is really important. But again, the devil will be in the details. Where are the, where are the resources? Is this a well-resourced place? Is this a place where people are well trained in principles of equality? So it's a fantastic. It's a fantastic resource if it turns out to be well resourced. But that's the thing to me that speaks to me most in all of this, in terms of what young people have told me about what they want and what they need and what they understand their friends to want and need in online harm. So we've been talking about the e-safety commissioner model for a really long time.
Sure. Well, and I think that a key theme that's coming up then too is proper resourcing is absolutely crucial for this to be effective in any way. And as you mentioned with the safety commissioner too, this teasing out of education as being a key component of it. I think that's a feature that you see. That is a key role of the Digital Safety Commission. And I think that's important because if anyone here has children, and I've watched my kids go through it, that education on this front is lacking or have some very different approaches. And so being able to build capacity generally for the public and for children will be great. Where are we at with questions? One might be, do we want to move on or talk about the regulatory structure briefly? Yeah, so, and that might be a good moment because you've brought up the Ombudsperson's office. Maybe I'll start with you, Sunil. The basic structure, this idea that you have this commission and the ombudsperson, and then they're both supported by the Digital Safety Office. Do you think that's a good structure? Or are there things that you would change about it or you want to flag as alarming?
That seems to make sense to me, right? The ombudsman is there for the public. It empowers them. It provides them with information. It directs them to resources. And then the Digital Safety Commission is the body that has the T, right? The transparency, enforcement, accountability, and then the Digital Safety Office makes both of them run. That seems to make sense to me.
Michael.
Yes. Well, I think this is a really difficult problem because as has been clear, I have some real reservations, at least about the level of detail that they've structured in to the Digital Safety Commission. I recognize somebody has to enforce this, and it's not going to be the government. Better not be the government, and it ought not to be the CRTC either, given what we've seen with CRTC. So there isn't an obvious place to turn. So I understand that they got to choose something. I think as I've mentioned, I really do believe that this legislation rises and falls with the commission more than anything else. There are elements I like. I mean, this notion, I think the transparency side is enormously important and really valuable. Consistently you hear from people that file complaints with platforms or social media companies, that it's a very opaque process, that they don't know what happens. Some of you may know I had posted a picture of some anti-Semitism in Toronto a number of weeks ago. It was taken down by LinkedIn. I'd provided context, but it got taken down. I appealed. It went back up. It came back down again. A couple days later, it went back up again with a note that they'd reviewed the file. I must admit, I still don't know why it was taken down or, frankly, why it was put back up. And so processes that kind of pull back the veil to allow us to have far greater transparency, I think will be enormously valuable. More data associated with what platforms are doing will be enormously valuable. But, where the rubber is going to hit the road in terms of some of the challenges will be that so much of this is still open to interpretation. And yes, there's value in having an entity that will provide the staffing that's necessary. But at the end of the day, we still are going to look to 3 to 5 commissioners to make a lot of calls. And I look at the CRTC, which obviously is a larger number. I look at, frankly, just the kind of expertise that one would hope to see in commissioners. And I have a very hard time thinking that 5 people are actually going to ensure that we have that sort of representation, never mind the usual regional representation that we will always kind of emphasize in Canada and the like. So there are going to be these kinds of pressures. Are you really going to get a panel that can move expeditiously and informally and ensure that freedom of expression and privacy are factored in, because you've got people who have that expertise and are expert on children's harms and are expert on some of the other issues? I find myself a bit skeptical.
Yeah, I was trying to write a list in my mind about, okay, what are the expertise that we like? If you were going to write this into the legislation, what do you need? I mean, you need people who have the tech policy expertise. You need freedom of expression expert. You need someone on there who is a child protection expert.
You need to have, people from across Canada.
Across Canada, yeah.
Because there is different sensibilities and approach and stuff, from the east to the west, and Quebec and Francophone, etc. So there is a lot to be taken into account. And interestingly, there is nothing in the act. At the same time, how do you add this and define? But in other acts, there is purple in C-27, the tribunal. There is only 3 of the members of the tribunal need to have an expertise in privacy, which in between all of them should. But yeah, like in other acts, we see those kind of requirements. And I think it's interesting that nothing is done. That may be something that, in Parliament,
I mean,
would hope MPs or senators to like add in the act to ensure that,
More clarity about requirements that or expertise that may be helpful, but I think about similar, problems and similar difficult decisions that have to be made, right? So there are human rights tribunals across the country. They have to make very difficult decisions about whether there's discrimination in employment or in housing. You have human rights commissions that have a systemic role, like the BC Human Rights Commission or the Ontario Human Rights Commission. They have to set priorities. They have to respond to emerging forms of discrimination. They have to engage in public education. These things are really hard, right? And so I wouldn't throw the baby away with the bathwater because it's so difficult.
Sorry, to be clear, I don't think there was a suggestion that we just toss this aside. It was simply to say that I think the more we set up the Commission for Success within the legislation, so that there is clarity, both in terms of a lot of the kind of responsibilities, the oversight that's built in, more and more on the composition. The greater likelihood, in my mind anyway, it has to succeed. But as I mentioned, sort of similar to the discussion sometimes around the CRTC, when people talk about abolishing the CRTC, and if we did, we would still have to create some entity that has some of the same kinds of responsibilities. I think the same would be true here. If you said no to the digital, and as I say, the existing entities that we have or agencies that we have seem even less well suited to creating something that's a bit more bespoke.
I'm conscious of time and that we do need to move on. And I'm glad that you mentioned the transparency aspect, because it's such a core aspect of this that I didn't even mention in the overview, which is that we're looking for transparency from platforms, and these digital safety plans are key to that. So I thought it was fascinating that the data that extracts from platforms, I will say just 2 points. One, I think that it should be part of the digital safety plan should be that the social media services do report on their accountability for freedom of expression, privacy, and equality. That is not there. It says that they may, but it doesn't say that it's required of them. It's required of the commission, but not required of the companies. And I think that should be embedded there. And also, I think that some of the data might be more difficult to extract from companies than it seems. I just know I did some work with the OECD in developing these and was working with many different social media services and companies that support them, like Tech Against Terrorism. And I mean, some of this data is more difficult to put together than it seems. So it was interesting to me that detail was actually in the legislation. I wondered if that data maybe should be left to regulations, because of the fact that I was surprised to find out how hard it was to gather that data. Okay, let's move on then to the criminal code. Shall we move on to that? I had down that maybe we'll start with you, Jane. I'd love to have your comments on that, and you can really start where you want. I mean, the standalone new crime, the risk of life in prison for both advocating genocide, and the new standalone crime, and also the new peace bonds provision.
Yeah. So first of all, I actually can't help but say something more about the digital harms legislation, which is the other thing that we know from the experience in the Safety Commissioner in Australia is that the functionality of an ombuds or support person achieving informal outcomes is enhanced by knowing that it's backed by an ability to enforce if it has to happen. So those two things, I don't think they exist very effectively one without the other. And I do share Michael's concern about the well-being of the 3 to 5 commissioners. And I would also say that I think we have to think beyond legal and constitutional expertise and be conscious of the fact that members of the communities that are most affected by this are well represented in in these decision-making processes. In terms of the criminal code, I'm very conscious of the abuse of the criminal justice system against members of marginalized communities, the very marginalized communities who are also disproportionately targeted by the kinds of crimes that are here advocating genocide, incitement of hate, and so forth. And so that makes me concerned about criminal law provisions. So I approach them very cautiously, and from that point of view, I do think it's interesting to think about peace bonds and the capacity of criminal law is always reactive, and the capacity of the peace bond to be something of a proactive intervention that might allow us to engage in issues before the horrible outcome happens. That being said, I have tried my best to understand where the gap is, if there is a gap in the existing criminal code provisions that needs to be filled by this new. It isn't. We call it a standalone offense, but it isn't even really, because it has to be prosecuted in tandem with some other offense. And I think it would be really helpful if there are examples of that those could come forward so people could understand what is it exactly that this new crime is meant to address that we can't already address, because we have existing hate crime provisions. We have provisions for removing content under 320.1. We have peace bonds that are available for other kinds of offenses, that including terrorism, that could be related. So I think it would be super helpful if someone were able to come forward to give the concrete examples. And this is often not the case when criminal legislation. We saw this with the non-consensual disclosure of intimate images offense, that along with that came this increase in police powers, which weren't necessarily obviously tied to the particular harm that was being addressed by that, what I think is an important criminal code provision. And so I guess I'm a little bit concerned about whether everything that's in there is something that we need, while at the same time acknowledging that if you are a member of a targeted community, and for you, community denunciation of what's happening to you in the strongest terms is important, and you think you can achieve justice through a criminal justice process, I don't see myself as being in a position to tell you that that's not what you have a right to and that's not what you deserve. We should have other ways of resolving really serious problems in our community beyond criminal justice. I think we all know that, but at the point in time when that's the mechanism we're using, I don't feel like it lies in my mouth to tell people who are targeted by this kind of content that they should not have right to a criminal justice system. I don't know if what's in here in addition is needed or not. So it's like my mixed bag.
Sure. Did you want to go ahead? I'm happy to jump in, but you can go ahead first.
Sure, yeah. I mean, it's always best to think about examples, right? So if there's reasonable grounds to fear that someone's going to commit a hate crime, like vandalizing a mosque or a synagogue or a temple or a religious school, and that's a high standard, but if there is that reasonable grounds to fear, and you still need consent of the Attorney General, right? Then it seems to make sense that you would need a peace bond. And I'm fully on board with denunciation and the awful impact of hate crimes, and you need to show a signal to society that this won't be tolerated. And, I understand that having a standalone hate crime provision provides some clarity on the definition of hate crimes, right? Because you have various police services across the country who have different definitions of hate crimes. So this could provide some more clarity and more data collection. So I understand that those are also important. But I really agree with you, Jane. Like, there's got to be other ways, and that's why I think the Canadian Human Rights Act changes are really important.
You've teed that up already. Okay. Michael.
Okay, but before we get there,
Yeah.
so I mean, I think it's an enormous mistake to have included the criminal provisions in this legislation, both in terms of what we've seen as the public backlash to it and the commentary, which I think has created a distraction at best when it comes to this. So, the core of the legislation, the stated goals of the legislation were not really on this issue, and I think it's attracted perhaps the lion's share of attention, which I think is ultimately detracting from having the kind of debate that needs to happen around online harms. As Jane suggested, I too have been trying to find someone who can tell me that the problem we have with the criminal justice system and hate is one of insufficient provisions or the need for longer penalties in the act, and I can't find in the code, and I can't find anyone that tells me that. There's a policing problem, there's a resource problem, and frankly, we've seen some of that over the last number of months. But the notion that if only we had longer penalties, this would solve the issue, I just don't think there's really any evidence for it. And I'm not a criminal expert, but as some of you may know, I also have a podcast, and Richard Moon, this past week, Professor Richard Moon talks about the Human Rights Act stuff next week. Download it. I've got the president of the Criminal Lawyers Association, and we spoke yesterday, and he was able to identify a whole series of things that, unless you practice in the area, you wouldn't otherwise necessarily, I think, clue into the fact that, for example, inclusion of a term of life means that this now is an indictable offense. There are no summary convictions based on the fact that we've included life. There's no discharge available with when life is available. So if you think of someone, let's say, that gets in a barroom brawl and says something hateful as part of it, it's not clear if that's now motivated by hatred. So it's assault. Is it motivated by hatred? Sort of thing that you might want to provide a discharge on. You can't. Because life is associated with this provision as well. The standalone provision doesn't require AG approval, which in many instances other provisions do. By excluding AG approval here, what you're doing is running the risk of creating an increased imbalance between prosecutors and the defense when it comes down to plea bargain or other sorts of negotiations, because you don't actually even have to go get the AG approval. It's prosecutors that are in a position to do this. So I think it creates real world granular problems in terms of how criminal law actually tends to function. I don't know if these were accounted for as part of the considerations, but it's quite frankly, in my mind, indefensible. And the attempts to defend, which we've seen from a recent addition at the PMO, which is gone to a bit of a Twitter spat with me, which is basically to say, don't worry, there's sentencing guidelines or there's reasonableness requirements. It's just is completely beside the point about the kinds of both implications of having put life in prison here and the power imbalance that gets created when addressing some of these issues at the time when most of these issues actually do get addressed. It's not that we're looking for appeals on this stuff. We're actually looking for ways to deal with these in the most appropriate manner. So a terrible mistake, and a terrible mistake also because this is a time when many Canadians, certainly in my community and a number of other communities, have been looking to the government for leadership on hate. They could have put forward online harms separately and then said, here's a separate bill. It deals with criminal code. It deals with Human Rights Commission. This is part of our response on leadership in dealing with hate, and we can have a debate about it. And instead, they, I think, have mucked up the entire bill.
I just like to comment on that. I think fair enough from the government's point of view that we can agree or disagree whether we think criminal law powers are what's here is needed or it's not needed. But fair enough, because a lot of what's been out there hasn't talked about the nuance of it, which is you don't have to charge. You don't have to add this to the barroom brawl. You do not have to add that. The judge doesn't have to give life. It's up to life, right? That may not be an answer for you at all, or anyone else at all. But the fact of that nuance, I think it's important for it to be out there. I think that there's been some sort of knee-jerk reaction to some extent that's sort of taken things a little too far, and in some ways, for me, undermines the sort of validity of some of the really substantive concerns that are there. And so the other thing I think to keep in mind is I don't, as someone who's been sort of working in this area for I don't even know how long, since 2002, I guess, or like 1999 or something like that. And talking to young people for years, we've been saying, if we want to address these issues, we have to have a panoply. We have to have a multiplicity of approaches. And that's part of what's happening here. What are the multiplicity of approaches? Let's deal with what service providers are doing. Let's deal with criminal code provisions. Let's deal with human rights provisions. So, and these are the things that are in the power of the federal government to do. So to me, they aren't completely unrelated. In fact, they're part of a spectrum of approaches that look to different players who have responsibility for what's happening in the online environment, and which can't, of course, be divorced from the physical environment, because these things are very fluid and very connected.
Yeah, can I just quickly say, listen, the government framed this and its overall internet series of legislative initiatives were largely about about what we think is appropriate for large internet companies for these platforms. What kind of contributions do we think they ought to be making on the cultural side? What kind of support do we think they need to be making on the news side? And what sort of responsibility do they need to be taking for the content on their sites? And I think it fits together. This was not framed as, this is an omnibus bill designed to deal with as many different mechanisms to try to deal with some of these issues, some of which already exist. And so I think it would have been a more coherent approach to have done that. I don't think that precludes the ability to provide some of these other sorts of things, but by having inserted this into the legislation in the way that they have, and I think peace bonds you can make a more defensible inclusion. But having included something that you could say, well, a judge doesn't have to give life. Well, clearly judges should not be giving life in prison for a simple assault or for some of the range of different things that might exist. But the fact that it's even there it just makes no sense to me whatsoever.
But it wouldn't be a simple assault. That's the point. The point is that it's an assault that's aggravated by a hate crime, right? So it isn't like
that it's been motivated by hatred, which isn't defined. And so if someone, as I say, gives someone a punch and says a hateful term is part of it, is that now an assault that's motivated by hatred, and we're going to lock them up for life?
Well, they're not going to be locked up for life, but it would certainly be important in sentencing, and it needs to be important early in a police's investigation. And those are some of the reasons that support a standalone hate crime with a standalone definition. But, we talk about, let's get rid of the criminal code and the changes to the Canadian Human Rights Act. But what about access to justice for people from equity-deserving groups, right? Think about the changes to the Canadian Human Rights Act. If you got rid of them, how can an individual person be made whole? If they are looking to be made whole through pain and suffering as a result of online hate, they can go to the Canadian Human Rights Commission, right? So what about access to justice for those people, right? And same goes, in the most extreme cases, it's
Not saying that first of all, we already have provisions we can debate the Human Rights Commission. We already have
What if
provisions
instead
that
of
deal
up to life
with this on the
service
criminal
between they
sorry.
put in an amendment that says you can go summarily or by indictment for the new hate crime stuff? What about that?
Well, I mean, one gets the sense that at least on the life in prison provision, that perhaps this was just a poorly drafted provision. And what they really wanted to do was match the term with the crime that it's associated
Yeah.
with, and simply wanted to clarify to put that in. If that is the case, this is a very poorly drafted piece of that provision is poorly drafted, and one would hope there'd be a willingness to change it. I must admit, I don't know if people have listened to the Althea Raj podcast that she put out on this legislation, which I would highly recommend. It was excellent. Emily's on that, as was I, and I thought it was very, very good. And I was quite discouraged, I must admit, by the Justice Minister, whose response to many of the kinds of concerns that have been raised was repeatedly to say that he challenged the premise of Althea Raj's question on a number of these things. So I went in being more hopeful that the government would be open to say they want to fix some of these things, but I left that hour of a podcast being left somewhat unsure.
I listened to the same podcast and I heard that there was an openness. You know,
All right.
Well,
Not
so I know that it's time for questions, but I think we cannot move to questions until we do talk about Section 13. It is such an important one, and Smil, could you kickstart the conversation on that one? Should we reintroduce Section 13 in the version that has been proposed here?
I certainly think it should be reintroduced, and it is in the bill, right? So you're dealing with online hate that falls below the threshold of a criminal act, right? Or hate propaganda under 319(2), right? So it's a lower standard of proof. It's balance of probabilities. You don't have to prove intent. There's access to justice. A person who's a victim can complain directly to the Human Rights Commission. There's a gap right now because you don't have a mechanism to deal with internet hate through human rights. And there's access justice, right? So the best way I could put it is there was the Sears case, and that was it was decided in 2019. That was the first case that involved hate propaganda against women that was successful under 319(2), right? In almost 50 years of 319(2) being on the books. But under the Canadian Human Rights Act, when you had the old Section 13, you had a few cases that dealt with hate against women, against Indigenous women, against Black women. And then, so you have a huge gap in between the rise of hate, its devastating effects on equity-deserving groups. So, for example, in a 2022 national survey conducted for the YWCA and the Canadian Race Relations Foundation, more than 1 in 4 young women and gender diverse youth said they were personally targeted by online hate, and 1 in every 2 witnessed it. So you definitely cannot leave it up to just the criminal code. And there has to be a means of access to justice. And this version, it's a lot better than what was in the old Section 13 as it relates to freedom of expression. You have a definition of hate speech which corresponds with Supreme Court of Canada case law. The Canadian Human Rights Commission can decline to deal with a complaint if it indicates there's no hate speech, and the Canadian Human Rights Tribunal can award costs for abusive process. You know, I hear things similar, resource concerns. Oh, you know, what if the Canadian Human Rights Tribunal will be flooded with hearings? Well, then the answer is that they need more members. Oh, the Canadian Human Rights Commission will be flooded with complaints. Well, then the answer is the Canadian Human Rights Commission needs more resources. Or no, not enough people will complain. Well, we need to empower equity-deserving groups so they feel comfortable using these processes. So I think it fills a very important gap.
I mean, I don't think, at least the general public, all understand the sheer lack of options that are available to individuals that experience hate speech. And that really, at the moment, what is available is to go to law enforcement. and you might be able to go to your, make a complaint to your provincial human rights commission, but most don't see it as within their jurisdiction. I mean, it depends on the tribunal, but they don't see it as within their jurisdiction to deal with hate speech that's online. So that's it then right now. All that is available is to go to law enforcement, and for the most part, that isn't the appropriate route. I do think that there's some really interesting questions about how do you deal with the risks of a commission being overwhelmed. You said they should resource it more, and I thought, well, maybe they should create a bit more friction so it doesn't become the first place. I mean, it's not like someone's going to press a button and complain. So how do we deal with managing that? I see that as just an issue of maybe something needs to be in the legislation to address that. Maybe it should be more difficult to make a complaint. I remember I suggested that there should be an application fee, and I remember you were like, "No, that's a terrible idea." And
This is the
and I
final
know
refuge
this.
for people that are most disadvantaged. No
Yeah, I
application.
mean, massive inequities
Yeah.
with that point. But I was, you're trying to think through what can you do, and I'd be interested, Jane, maybe if you could jump in on this.
Yeah, I'll come out by saying I have a bias, so I've got a couple of things to say about this. So first of all, I was junior counsel on the very first hate speech case that went before the Canadian Human Rights Tribunal against the Zindel site in like the 1990s. And that was the first Section 13 case under the old Section 13. And then we were leading evidence about what the internet was. So that's where we were at that time. And so I think I'd be shocked if we had the problem that we actually have a flood of complaints to the Human Rights Commission. It may be, one of the frustrating things is we're in a time in the world where that may be a reality. And the thing that I guess annoys me the most is that Section 13, the predecessor, was repealed at the very time when it was most needed, right? And if we had left Section 13 in place, we would have the case law that would tell where the limits would be clear. And now we don't have that. And now we're in a place where there's a very real concern that these provisions could be abused. At the same time, I believe in the right of members of equity deserving communities to decide what route to justice is the right route for them. And I think characterizing this kind of behavior as discrimination and a violation of human rights is a really important way of understanding what is happening.
Michael, last words on this.
Sure. All right. Well, might as well take a bit more issue with it. I guess I'd point to two things. One, I haven't heard anybody say that they actually think this is going to make a difference in terms of the amount of hate that takes place online, because I frankly don't think it will. And so at the end of the day, my primary goal, I appreciate that there may be people who feel that they get an element of justice with this, but fundamentally to me, the goal is to find ways to mitigate the harm and remove and address as much of this harmful content as possible, and create disincentives for people to engage in that. And I'm not convinced that this does that. More to the point, you said people aren't going to press a button and file complaints. They absolutely are. The system will be set up. I look at my Twitter feed, look at a range of other people's Twitter feeds when they say anything related to anti-Semitism or Islamophobia, and the stuff that it generates is beyond belief. And we will see a ton of that. And the weaponizing of this, I'd be willing to bet just about anything that we will see groups say our new tactic to silence is to file as many complaints as possible coming out of social media content against a range of people. This will not have the effect of, I think, broadly in society dealing with this. This will actually, I think, in many ways shut up many of the people that are trying to speak out against some of these sorts of things, and will create a situation where maybe you get the way the commission deals with it is just dismiss. And I recognize they've got the ability to do that. So there is the structure for that. But I don't think anybody should underestimate the impact that a notification that a complaint has been filed against you, or 1,000 complaints have been filed against you as this becomes weaponized is going to have on people's ability and willingness to engage in some of these issues. I think there are serious risks associated with that.
So let me just say one thing before we move on, because let's play this out for a second, because when I take your point that weaponization risk from groups that are coordinated and this is their goal. We see that with online abuse all the time. So why would they then not weaponize this process? I was thinking more in terms of pressing the button. It's not like making a complaint to Facebook. You actually have to sit down, you have to properly fill out these complaints. You have to go through this process. So it's way more burdensome than just flagging something to Facebook.
And what about costs?
Yeah.
For abuse of process? If there's that abuse of the process, you can get hit with costs. That's a disincentive.
It doesn't strike me, based on what we've seen online over the last 6 months, I'm not convinced that that is going to be much of a disincentive.
I feel like we could talk for hours about this, but I would like to give the opportunity to the audience online in the room to ask questions. So people in the room, you can go to the mic to ask your question. Please don't be shy. And we have already questions online. And the first one, I will direct it to you, Emily, because I know you did a lot of work on this on the UK, etc. So people are wondering online, and I'm sure so in the room, know how does the bill and the proposal compare to what we've seen in other countries, like the UK with the online harm legislation, like the DSA in Europe, and also Jane had mentioned Australia before. So do you think we're kind of maybe for once leading, or yeah?
I do think that we're leading, and it's not that there aren't tweaks when it comes to the Online Harms Act part. I mean, I have recommendations I think that could be tweaked, but I do think that we're leading to the extent that we've picked the best of different aspects of different bills. I think the UK goes way further. They're even still dabbling with the idea of they've left on the books the private messaging provision, much broader scope when it comes to the types of harms, and that was introduced by and passed by a conservative government in the United Kingdom. So I actually think that this really is an issue of concern to everybody in government, whether you're liberal or conservative or other. The European one I think goes much deeper when it comes to the types of services that are captured. But they also cover things like mis and disinformation that were left out of scope here. And the e-safety commissioner, it's interesting, Jane can speak on it. It started very much as a child protection commissioner, and over time has grown since then and has taken all kinds of different issues. And that has made sense. I think that ship sailed. I don't think there's any way we could have introduced this type of legislation for online harms in Canada and just focused on child protection matters. But that power to take down by a commissioner swiftly things like intimate images is a power that the Australian commissioner has. And I was hoping that would exist here. I didn't want to see that pushed through a tribunal, because what's the point? Then just don't do it, right?
Maybe no. Okay. Laura, please.
I have the annoying question that no one actually wants to be asked on a panel, which is, if you had to vote on this bill and no changes were made to it whatsoever, would you pass it or not? With the second follow-up of, if you got to make one single change to fix the bill, what would it be?
Bundled or unbundled?
I mean, it's your answer. You guys can all answer as you want. I'm not here to tell you how to be on your panel. You can answer it however you'd like.
Michael?
Sure. Well, since it's my answer, I will say that I would move to sort of, I think, for that coherence of saying we'd go with with just the online harms piece on its own. I think with it all together, I guess I think it's important to see the online harms piece happen, and I genuinely feel that there is a risk that this whole thing sinks, based on on some of the provisions that at this stage don't make a lot of sense. Doesn't mean the government can't try to salvage it. So if we're looking for a single provision, it'll probably be the criminal code provision with life, because I just for the life of me, so to speak, don't really understand why it's there. But I do think that I think the online harms piece is a good start. I think that we can work with it, but I also think that there are elements there, especially around the commission, that I would like to see some pretty robust changes on.
Jane?
So I think if push came to shove, I wouldn't, for the reasons Michael has articulated, I wouldn't want to see the online harms legislation fail. I don't think we can afford to mess around a lot longer with this. So I guess I would say I would do what it took to make sure that didn't happen. I'd love to see a little more about equality in that legislation, and a mandate to think about, to require those kind of considerations in the planning, and to inform and infuse everything that Digital Safety Commission and the ombudsperson are doing. Because to me, that's the heart of online harms. It's the impact, it's the disproportionate impact on equality-seeking and marginalized communities. And that should be the heart of what we're doing. And to the extent we're limiting freedom of expression, even to any extent in that name, then we need to be thinking about that in terms of substantive equality.
I don't disagree with the importance of expertise on equality and making sure the commission is filled with the members know the lived experiences or have the lived experiences of equity deserving groups who are facing a huge rise of hate. I think that's important. I wouldn't want to abandon the changes to the Canadian Human Rights Act and clarity about hate crimes. I think that's important. I defer to prosecutors and criminal lawyers in the field, and if they're talking about issues with the life sentence thing, I would defer to them. But it makes sense to me that if you have a murder motivated by hate, of course, then there's got to be a life sentence. And I think about the 4 members of the Upsall family who were murdered in London, Ontario. I think about them when I think about a life sentence, right, for the perpetrator. So, I mean, it's pretty clear where I'm sitting. I wouldn't want to lose all those things. I wouldn't want to lose the bill. So I would, if I had to choose, I would pass it.
On my end, I would maybe pass like the Online Harm Act, not the others. And if I'm allowed one amendment, and if I'm not allowed, because I think I'm not with your question, I would then push for a private member bill, actual whistleblower protection, because I think this is something that's like lacking in the bill, and we have even like less protection for employees than for the public in the bill. So I would push for this agenda.
I would pass the Online Harms Act. I would pass the Canadian Human Rights Amendments, Human Rights Act amendments. The criminal code provisions, I will say I struggle with, because I defer a lot as well to criminal lawyers on that one. So I find I'm just gathering a lot of information and trying to kind of demystify some of it. I think that, no, it's not a thought crime, what's being proposed for the peace bonds. That actually might be a really important tool, but I don't know enough about, well, can you already get a peace bond for some of the risks that you're talking about here, like threats to property damage, if there's threats to put like swastikas on synagogues or something similar, which is an example that's been given to the government of where this might be needed, right? So when it comes to the criminal code provisions, if I was forced to pass the whole thing, I probably would right now, because I think that some of the suggestions about the criminal code provisions are offside. But if I could do it my own way, I would unbundle deal with those separately, and leave the criminal code provisions to all the criminal law experts and practitioners out there.
And maybe support my bill. No.
Oh, and Florian's bill, obviously.
Next question, please, Jenica.
I just want to say thank you to the panel. And then, I mean, I'm concerned about the Online Harms Act is coming at a great time. I mean, it's needed now more than ever, probably. But I'm just concerned about the problem that we've always had, which is okay, so the Online Harms Act provides for age-appropriate designs and safety by design mechanisms. But there's always been a need to do age verification with social media platforms. And that has been observed more in breach, right? So you have instances where people either just skip or they put false responses. So I'm wondering, in terms of enforcement, how do you think the Digital Safety Commission can enforce this age-appropriate designs? Especially, okay, so age-appropriate designs are a good idea, but how would they be enforced without creating a tension and interfering with the right to anonymity online, which seems to conflict with these things, and how also can it be complied with by those who ought to comply with it? Thank you.
I love your question.
Jen or Michael?
Yeah. Well, thank you for the question. I think that we do definitely, because I'm concerned about surveillance being the model that's going to happen in protecting children is that we're going to wind up surveying children. And I'll defer to Michael if he knows about technologies in this regard. But I would have to assume that there are that if there aren't, they don't exist, that there have to be age verification mechanisms that can actually protect individual identity while at the same time accomplishing some of our objectives. But I share that concern, and so that's one of the reasons why when I look at it, I say, well, if we mandated providers to set up an environment that didn't invite so much disclosure and magnify conflict and amplify conflict, then maybe like we would be focusing on a different part of the problem. We'd be going to the source instead of the symptom. But that's kind of a cheating answer.
Yeah, I mean, you brought up age verification, which sort of creates a bit of a trigger for Bill S210, which is another piece of legislation right now that does envision age verification for access to pornography. It does a number of other things, including website blocking, amongst other things. I think it has a range of different issues, but for age verification, and they have cited specifically the current state of technology. And I think the general view of where things are at today is that if you're really looking for true age verification tech, you do it in two ways. One is you require people to upload IDs, which creates some obvious privacy risks if you're now uploading government-issued IDs. The other is you engage in sort of facial scanning that is supposed to try to identify roughly how old the person is. There are a couple of problems with that. One, I think it has the effect of even further normalizing facial scanning and facial recognition in a way that I think is societally harmful. But beyond that, technology doesn't work. The technology companies that cite this point to use cases where they can distinguish between someone who's 23 and someone who's 16. But that's not the use case we're talking about. Or in certain circumstances, we're talking about distinguishing between someone who's 17 and 18. Technology is just not good enough to do that. So there, I think, are real privacy risks and I think real shortcomings for now where the technology is. And so I personally, at least at this stage, did not take the inclusion of age-appropriate design requirements as creating requirements to engage in age verification or mandating the use of that technology. And frankly, the government had an obvious opening. They've got a bit of an issue on S210, and if they wanted to include it, they certainly could have. It seems to have been a conscious decision not to have included that at least as a stated requirement within the legislation.
And it's more similar to the Digital Services Act in the EU, which is basically like you need to look at protecting children in whatever different ways are available, and it might include this or that. And actually that's the types of things that they can leave to develop later through regulations or different guidelines. So one interesting tidbit before we go to the next question is I just read the statement of claim by the school boards against various social media platforms. And I thought one interesting thing they did was they were suing for negligence in various forms, was they said that social media was negligent for not putting in place and not using age verification for like TikTok and different platforms. And I thought that's going to be really interesting to litigate because they're saying the standard of care is actually the use of age verification technology by these companies. So that'll be interesting to litigate. The next question, maybe I'll answer this quickly because it's disinformation, and I mean, anyone else jump in too. It's disinformation is a recognized harm with real world consequence. The person said, I recognize the special difficulties in regulating it when it comes to freedom of expression, but how can it be addressed if not through this bill? I think that it is one of the major threats that we are facing. But the legal challenge we face, and a very important one, is that we are allowed to believe and talk about false things except in narrow circumstances. And it's incredibly difficult to tackle this through this kind of legislation that doesn't have all kinds of knock-on effects. I think that where we should watch over the next years is how it plays out when the EU experiments with it, because right out of the gate, there were accusations that they were making value judgments in the Israel-Gaza war, and making decisions right away about what was disinformation and what wasn't. That that I thought pointed clearly to the reason it shouldn't be within the bill here. There are other ways to deal with it besides through online harms legislation, including through education. Through actually one of the ways some of the studies have shown has been public broadcasting, public support for public news. So I think there's a lot of issues going on in that space. I don't know if anyone has anything to add about disinformation. The last one is is this the last question? Yes. Why don't you go? No, go. How much of the impact around the debate of the online harms bill are a direct result of the struggle the government had with Bill C-18 and C-11?
Sure.
How much of the impact around the debate, so how much of the debates about the online harms bill are really just flowing from the struggle the government had when it came to the earlier digital bills?
Yeah, I think. So I guess I could start by saying it. Yeah, no, I know. Well, listen, I think both for some, it's clearly correlated because there's a view of the way they view C-11, C-18 just naturally assumes that this must be the same. And in some ways, the kind of surprise, so to speak, that people had when they saw this legislation and saw that, in fact, it reflected some of the work that you did and on the expert panel and others it was nice to see that it had veered a little bit. But I will say that I say it with all respect, I think the government has lost a lot of credibility when it comes to its internet regulation approach. I think that not just with the approaches that it took. I mean, in the case of C-11, they said they weren't interested in regulating user content. They insisted on including it in the legislation anyway, and then still put forward a policy direction afterwards. I, for the life of me, don't understand why, if that was the intent, that you didn't exclude it altogether in the first place, so that it wouldn't go through more than 2 years of fighting. And I am hard-pressed to find almost anyone who thinks C-18 has actually been a success, and part of it was a repeated refusal to heed any of the identified risks that were raised continuously. So, in this space, I think the track record recently has not been great. And so there is, for some who have followed it closely, a tendency to say, well, isn't this just more of the same from a government that has not done a great job on this? And I think in some ways it's unfortunate because this is not more of the same, at least with respect to some of the internet-related stuff. It really does feel like it would have been had they gone ahead with that approach back in 2021, but they didn't. And they really did listen. And so there is, I think, a bit of a hangover from what took place. I think it's a fair observation. And perhaps part of the strategy of moving the justice minister to be responsible for the bill is a bit to signal that there is a bit of a change in how they're approaching this bill. Wilson.
Although Section 139 is kind of like the same framework. Anyway, I think, except if Jane or Sonali want to react on this, I think our conversation gonna come to an end because we'll like run over time. I'm very sorry. I know there are like other questions, but so thank you so much for being with us tonight, online and in person. Thank you, Michael, Jane, Sunil, and Emily, for being with us tonight. And I'm sure this is the first of a series of conversation on this topic. Thank you so much. Have a good evening. Bye-bye.